Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna PC, immigration.com. This is our bi-weekly, every other week, community conference call every other Thursday. We'll do our best to answer your questions. This does not create an attorney-client relationship, nor can the information be guaranteed. We just do the best we can for you based upon the information we do have. Let's begin, as usual, first with the frequently asked questions, and then we would begin, and we would then start with those that are not frequently asked questions. So, Nirav Bhatt wants to know about father's visit and visa extension. He's got a B1, B2 till 2025. I-94 is good till August 4th. Like to extend his stay in the USA. He's visited USA multiple times from 1987 to 2020. So I don't have any problem with applying for an extension in these circumstances. And you can make it clear to the government that I don't want him to travel until this situation is well in hand, because he is not a young man anymore, and we would be very nervous with the health risks associated with international travel, especially because planes are a closed environment and the same air is being circulated. It is just not a comfortable thing for anyone to have their parent go through. There is just too much risk. I think you can make that clear. So I'm not that worried about the chances of a visa extension, because by the time they get to the status extension, it is already past 6 months. And that's the problem with B1, B2s. So typically, you will apply for a B1, B2 requesting 6 months stay extension, and it'll take them more than 6 months to decide the case. So your father would be ready to travel out before they decide the case. Therefore, I think it's unnecessary to worry about this. And as I have mentioned this before on several occasions, I'll state it again. The important thing is to get the application filed. It is not that important to get it approved. And make sure he keeps some proof of the filing, timely filing, because next time when he comes back, they could ask him at the airport, why are you coming back? Last time you stayed 1 year. So make sure that when he leaves this time, he doesn't come back for at least a year or so. Other than that, I don't see any other issues in applying for a stay extension under B1, B2. Press *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question. Okay, let's go to the next frequently asked question, which is, what's the effect of this immigration proclamation, this executive order on green cards? Well, first of all, it doesn't apply to people who are already in the United States. So people who are doing adjustment of status, etc., it has no application on them. They can continue. It also does not stop people from applying for a green card. It just says that we won't, if you are outside USA, again, it doesn't apply to people inside USA. If you're outside USA, we won't give you a visa stamp for the green card for the next 60 days. So it's a 60-day suspension for green cards stamping, not the process, not in any other manner. The process can still go on. If you want to apply for an I-130, you can. We just won't give you an immigrant visa stamp on your passport for 60 days. Okay. So the questions here are, I'm a US citizen, received green card via employment-based category. I've sponsored the green card application for my parents who live in India via counselor. I-130 is approved, DS-260, 864, etc. Everything is done. Does the executive order impact their case? And the answer is it impacts only to the extent that they won't get the immigrant visa stamp on the passport for the next 60 days. That wasn't going to happen anyway, so I don't think it's a big deal. Personally, I wouldn't worry about it. Just it's a matter of time. Eventually, it will get resolved. Okay. Star 5 if you have a follow-up question on this. Star 5. All right, so let's go on to the next frequently asked question. For people who are just joining us, first I'm going over the frequently asked questions, those questions I think get asked a lot by the community, which will be separated and put on immigration.com under frequently asked questions. So Dr. Geeta says, I'm a dentist practicing in California. I guess she was working for I think it's a federally approved facility. That's what she's saying. And there was a temporary layoff. She was placed on unpaid leave while on H-1B. Is my present status okay, or am I on my 60-day grace period? Okay. So first of all, the 60-day grace period only begins if you have been terminated from employment. And the termination can only happen if the employer does three things. Most important for your purposes is the number one. They have to tell you, doesn't have to be in writing, they have to tell you that they are terminating your employment. If they don't tell you, they have failed to terminate your employment. So there's no question of a 60-day grace period. What does that mean to you? If you filed a complaint with the Department of, Wage and Hour Department of the Department of Labor, if you filed a complaint with the WHD, Wage and Hour Department, they will get the money for you. Because if the employer doesn't fire you, they have to pay you. And if they want to fire you, they have to tell you. Smart thing is to tell it in writing. But even if they do it orally, nevertheless, they have to inform you. Excuse me. Okay. So you have not been fired. Obviously, you don't know you've been fired. They just said unpaid leave. There's no such thing on H-1B. They have to pay your full salary. And if they won't pay it, Wage and Hour Division will make them pay. And it doesn't cost you anything to file a complaint. My H-1 visa expires July. I was told they cannot renew my visa until I return to work. How soon or late do I have time to apply? So, in order for you to continue working and be in status, your H-1B must be received by the USCIS before your current H-1B expires. So, your deadline is to get the physical filing over to the USCIS before your current status expires. And Nivedita had a follow-up question. She says, I'm currently furloughed. My employer has not revoked my H-1. I have a stamped H-1 with I-94 good till 2022. If I find a new employer on the 65th day, can they activate my H-1? By exiting and entering USA? Yes, of course. Yes, of course. You can always go get a visa stamping done. But that's not the only question here. One of the issues here is they have not revoked your H-1. And as I told Dr. Geeta earlier, if they haven't revoked, you are still considered to be working for them and they should be paying you. So if I were you, what I would do is file a complaint against the lawyers stating that they haven't paid my salary. And when you file a transfer petition, whether it is on 65th day or 66th day or 200th day, of course, you could be subject to the unlawful presence bar if your I-94 has been revoked or expired. That's a whole another story. But having filed a complaint with the Wage and Hour Division gives you some claim to status. You can always claim, I was available, they didn't have work for me and they didn't pay me. And I think government may be willing to overlook the fact that you did not file a transfer within 60 days. Star 5, if you have a follow-up question on this, star 5. Press star 5 on your telephone. if you have a follow-up question. No new questions, just a follow-up. Okay. Then the next question is from Biswaji Ban, who says the implication of the 240-day grace period. So guys, the way I have looked at the law, when you are in H1B, L1, several other kinds of statuses, when you file your petition timely, you have a 240-day grace period to continue working even after your current status expires. So that's a very big advantage. But the problem is, what if the government takes more than 240 days to adjudicate? You would have to stop working, but you can still stay in the United States as long as it takes to get your case decided. So while the case is pending, you can work for only 240 days, but you can stay an unlimited amount of time as long as the case is pending. In the context of an H1B, if an H1B is filed with, there are several ways you can file an H1B, right? So two most common ones that are applicable to this scenario is you filed for an extension with change or an extension without change. If you file for an extension without change, you've got 240 days. But if you file with change, you can continue working as long as the case is pending. Okay, so is the case with transfers. Timely filed transfer, you can continue working as long as the case is pending. There's no 240 days grace period there. *5 if you have a follow-up question. *5. Actually, there's some other stuff in there. Area code 224. I'm not sure where that is from. 224, I can hear you. Where are you calling from, sir?
Mr. Rajiv, I'm calling from Illinois. Just a follow-up on what you just mentioned.
Yes, sir.
So if H1B is filed without a status, without a change, that means just renewing for current employer.
Right.
Then after 240 days, are you out of status if you stay?
Oh, no, not at all. If your application was timely filed, you can continue working up to 240 days after the current status is expiration, but you can continue to stay in USA as long as the case is pending.
So I'm just not eligible to work, but I can stay here without accruing any unlawful status.
That is absolutely correct.
Understanding.
And another thing that we have done in the past sometimes is that while the first case is pending, what if we file another case requesting an amendment of the H1B? In that case, you can continue working as long as the amendment is pending. So there's a little bit of a play there that you can discuss with your lawyers that might be possible. Okay. So while this case is pending, let's say your job has changed slightly even. Let's say that instead of using, if you're a database administrator, instead of doing SQL server administration on Windows, you are also using the virtual machine or doing it on Linux. I don't know if that can be done, but whatever the idea is, the technologies have changed. So the point is, or if you're going from Microsoft SQL Server to Oracle Database Administration, different technologies, we can say it's a change. So we need to file an amendment. Normally an amendment is required if there's a substantial change. Okay, and I think when an amendment is filed, you can continue working as long as that's pending. All right?
Okay.
Good luck. Good luck, sir. Okay, so let's go on to the next frequently asked question. This is another one that comes up quite a bit from Devesh. I-485 is pending. I got laid off. What do I do? So the way this works is, your I-140 is approved. Your I-485 has been filed. Once the 485 has been pending 180 days and the I-140 is already approved. Remember, the I-140 does not have to be approved and then 485 must stay pending for 180 days. If you filed both together and let's say after 100 days I-140 got approved but 485 remained pending, then the 180 days is reached after 80 days. You don't have to start the countdown of the 180 days from the date of the I-140 approval. The language of the law is simply that your I-140 is approved and the 485 has been pending 180 days. Okay. Once that happens, you become eligible for your AC-21 portability. Okay. So that means, all right, so what if I got fired? No problem. Find a same or similar job or job offer. Remember, even a job offer will get you your green card. Doesn't have to be a job you're working on right away. So let's say that you started on a temporary project after you got laid off, and that's good for 3 months. And then there is another employer who's waiting for you to join them. You can just get a job offer from them and use that to finish off your green card process. There is a supplement J, as in John, process these days. In these cases where there's AC-21 portability, what exactly is that process? So first of all, it's important to understand what this is. Supplement J is sort of like an offer of employment. Instead of having a letter, you have the future employer or the present employer file your give you a supplement J, which is kind of a job offer instead of a letter. Okay. Now, do you have to file it? The answer is not unless the government asks you to. Should you file it? The answer is probably yes. So supplement J's should normally be filed. There is no timeline on how quickly you have to file them, and there is not even a requirement that you have to file them. Okay. Or the timing actually. Have to, I don't remember exactly. Some circumstances you have to, some you don't. You can check with your lawyers. I don't remember all the details off the top of my head. But definitely, there's no question about it that you can be without a job and get a same or similar job offer to complete your green card process. Okay. So some of the questions you had were, would it be all right to join a startup company? And the answer is yes, even if they pay less. Even if they pay less. But it should be assessed with your lawyers just to make sure that there is no other issue with this kind of a job offer. So what if the company is working out of a basement and they have no dependability? Although the government cannot directly question tax returns, etc., under the supplement J posture, but they can still question the genuineness of the company who's offering you the job. So therefore, startup company is okay taking on a little bit of pay cut. Again, talk with your lawyers. If you're taking a 75% pay cut, that may not be acceptable. There are many variables there. So yes, so that's something else you have your lawyers look at. Then you ask me, do I need to file AC-21 before joining? And the answer is no. You can take your time about it. Only time you have to file it is when the government asks for it. So if the USCIS sends you an RFE saying send your supplement J, then you have those 72 or 78 days, however time the RFE gives you, to procure an offer or a job letter. And that is in the form of a supplement J. Third question, what about my wife's AOS, which is also based on my I-140? No, there's no AC-21 for her. It's just for you. Your wife would not have to file an AC-21. Does my current immigration situation allow me to open and own a startup? Yes, but. So if you go back to the year 2005, I believe in, was it January or December, that there was a guy by the name of Bill Yates who clarified that AC-21 portability of green card can be done for your own company also. But there is a trick there. Couple of problems. One is that if you are a startup, how dependable are you as an employer? Two, your job has to be same or similar. So let's say you are a techie and you are, let's say, a network engineer. Then you start your own company. And now you're not really a network engineer, you're more of a CEO. And those are not same or similar jobs, right? So there's a potential for problem there. Be aware of that. In theory, you can, but in practice, it's complicated. *5 if you have a follow-up question on this. No new questions. Any follow-up on this? Okay. This is from area code 713. 713, where are you calling from?
Hi, Rajiv. Thank you for answering my questions. I'm speaking from Houston, Texas.
Yes, sir. Go ahead.
So my follow-up question is, so let's say when the government asks for AC-21 or 485J, and at that time, for any reason, if it is not approved or rejected, do I have option to switch to another job or file another 485J, or that option is not there?
Well, that's a difficult question to answer. I have never faced that issue practically. But again, depending upon just my gut on how this would work out, if the portability is denied, government may ask us to submit another supplement J. Okay? If they don't, there's always the option of filing a motion to reopen with a new supplement J from another employer.
Okay.
I believe that should work.
Okay.
All right.
Because the thing is, the same and similar sounds very confusing to me.
No. It's not. It's actually not that confusing. Same is easy to understand. The jobs have to be same. Okay. Well, I understand if I'm a database developer, I'm a database developer. If I'm a system administrator, I'm a system administrator. Software engineer. Okay. There's the same jobs.
Mm-hmm.
But what if the technologies change? Instead of being a .NET developer, I'm now a Java developer. No problem. We look at the job duties, not at the technologies. So that's one principle. Second principle is that if job X and job Y require the same education, same type of education, so instead of being a database developer, you became a software developer or a database administrator, same education qualifies you for all three jobs. That's another same or similar. Another example of same or similar is if it's a promotion in the same field. So for instance, if from being a software developer, you became a senior software developer, lead developer, principal developer, it's still the job of a developer, just much higher up.
Or let's say if I become from, let's say, research scientist to research manager.
I think it's a promotion.
Would that still be...
Yeah. I think why? Because one of the indications of similar is if the previous experience qualifies you for the subsequent job. So because you were a research scientist, that makes you familiar with the lab procedures, etc., and now you can actually manage the lab.
Right, exactly.
Yeah. So I don't think that should be a problem.
Okay, thank you. I have another follow-up question.
Sure.
If we have time.
Of course.
So right now I'm getting another opportunity of like part-time, not exactly, basically half-time.
Okay.
So is it possible to take that offer for half-time and then in the meantime keep looking for full-time job?
Definitely.
And then
definitely.
Of course.
Definitely. Because in between jobs, when you have your 485 pending, there's nothing in law that says you cannot work in a totally unrelated field, or you cannot work part-time, or you cannot do 3 jobs, or you cannot just sit at home and do nothing. All of those are options.
Okay. So that means, because the thing is, if I take a half-time job now, and 2 months later, if I get a full-time offer, I don't want to, leave the project from my half-time job unfinished. So there might be a time when I'll be doing both. Basically,
that's okay
to finish up my half-time.
That's okay too.
Okay.
I don't see any problem.
Okay.
Good luck.
Okay. I think that's all. Thank you so much.
Oh, you're welcome. Good luck, sir. Okay. So let's see. Do we have any other frequently asked questions? Next page. Nope. All right. Let's go back to our regular questions. Oh, I guess there's another question. Sorry, guys. There's another question from area code 312. Oh, area code 312, where are you calling from? Hello, area code 312. Area code 312, we can hear you. Okay. Not sure what happened here. let us go on to our regular questions. The first regular question is from Shri Harsh. Can I travel during my STEM OPT or OPT extension? The answer is yes, you can. Just make sure you meet all the requirements. You should have a visa. Your I-20 should be endorsed for travel. You should have proof that you've been working throughout, that you've not violated your status. You should also know that your time outside gets counted towards your total, 60-day period that you're allowed on STEM extension to be out of work. So as far as I remember, you cannot violate that period also. Okay, but travel itself is fine. When you return, you should just have proof that you've been maintaining status and you're coming back to work for an employer who has the job open for you. *5 if you have a follow-up question. Okay. So Krupa wants to know, question number 3, does it affect my citizenship application if I take the stimulus money? No, that's for everyone. I don't see any problem with that. And even the unemployment, I don't see any problem with that. Next question. Okay, oh sorry, I forgot to ask. Any follow-up questions on these two issues, guys? Press *5. Any follow-up questions on these two? F1 travel and taking money? Okay. Next question is from Krishna. US citizen planning to apply for my parents' green card. I-130 and I-485. They are both above 65. How the new public charge rule affects their chances of approval? Well, basically they have to prove that they will not have to take money from the government. So if they have assets and you make enough money, all that would go into the determination, assets in India, etc., which you're planning to show. So as long as they can make that showing, I don't see why this should be a problem. Do you think attaching their health insurance, visitors' health insurance? Well, I'm not sure it helps much. The visa expires September 2021. Do you think it's better to renew their visitor visa? Well, if they are going to stay in USA, I don't see any point in going and waiting another year to get the visa extension done or visa approval done and then start all over again for the green card. I don't see any point in it. As long as they entered without any intention to convert to green card, and more than 90 days after they entered they change their mind, they can just apply for a green card, and that would be the smart thing to do. *5 if you have a follow-up question. Press *5 on your phone. Okay. So this one is area code 732. Is that New Jersey?
Hi Rajiv, that's a New Jersey number, but I live in Virginia.
Okay. Go ahead, please. What is your question, Krishna?
Yeah, I mean, like, previously, I think one of my cousins applied for my aunt and uncle's green card, and they did not have to show any assets in India. But I think with the new public charge rule, I think there is a separate form we have to fill, which is specifically for the applicants, right? I mean, I can show all my assets here, and I definitely make more than...
Right, you do have to fill that form out. That is correct, yes, sir.
And then do we have to, like, bring some kind of a proof? Because I think it's two things they have to prove, right? That they, in order to show that they need government assistance. One is like we have assets like house, land, and those things. But do we have to show like a monthly income or something, saying that hey, once they come back, they can rent their house, and this is the prospective monthly income they would get by renting it or something like that?
I don't remember the details of the form. It's a multiple-page form. But leaving aside the form, but just going by the general law and policy, all assets help. None of them is a required asset. So if somebody is retired, they're not going to produce a job letter. And somebody doesn't own land or rental income, they're not going to be able to show it. So whatever you have, you can show it.
Okay, thank you.
Good luck.
Thanks.
Nora, I'm very sorry. I don't know anything about undocumented area. Our practice is limited only to documented people, okay? Next question is from Rick. He's currently on a cap-exempt H-1 with a healthcare company. What if he gets offered a full-time position for a for-profit? One is to switch to CPT, and the other one is H-4EAD, but it takes so long. So yeah, you're right. Those two are the obvious options, CPT and H-4EAD. A third option may be, and I don't know how far that is possible for you, is to work for both jobs at the same time. I think I've mentioned it before several times. I'll repeat it again. It's a very odd process. So if you are working for a quota exempt employer, you are allowed to simultaneously do a concurrent H1 for another job, even another full-time job. So let's say I'm working for a university and I get offered a job in the commercial industry. I can get an H1B process to go concurrently, and this H1B is a quota H1B. As long as it runs parallelly and I continue to work on the quota exempt job, they can both run together. That's the only other option I can think of. Okay. *5 if you have a follow-up question, press *5. Kevin wanted to know about 864. If my aunt becomes a joint sponsor, oh, sorry, there is a follow-up question. Let's go back. Area code 908, that's New Jersey. New Jersey, go ahead, please.
Rajiv, thank you. I think there is a delay in raising my hand.
No problem. Go ahead.
So on the concurrent H1 option that you just mentioned, I think I still have to continue working on the caps exempt H1.
Yes. But another thing,
until I go to the quota again.
Rick, 1 second. So let's say you've got a 40-hour job with a quota exempt company. And if you want to work fewer hours, you can actually amend your H1B with them down to whatever number of hours you want to work, 10 hours, 20 hours. At the same time, you can file a second H1B for the quota employer.
And should those two match up to 40, or can that be more than 40 hours?
I have quoted that example many times. Number of hours you work each week is only up to your discretion and common sense. Many years ago, I had a case in which a guy had 3 concurrent jobs on H1B. So he was doing 3 40-hour each week jobs. How did he do that? Well, he was a senior system administrator, database administrator. So once the databases were up and running, they had their own database specialists. They would call him only for expert advice. But he got paid for 40 hours from 3 different employers for carrying 3 pagers. So the number of hours is only whatever is true and common sense. Okay?
Okay. And also, if I have to switch completely onto the cap subjective H1, they have to file my H1 in next April. Then only I can pull off my cap exempt H1. Right?
That is correct. Yes, sir.
Okay.
All right.
And another question I had is, if my green card is in process, does it stay on this cap exempt one, or can I switch over to the cap subjective one?
Well, the green cards,
if my 140 is approved.
The green cards don't care whether you are on a quota or a non-quota H1B. There are some things you can switch between green cards and some things you cannot. We have a frequently asked question on that. Please listen to it. It's a long discussion, so I won't be able to repeat it again. Okay.
Right.
All right. Good luck.
Also, couple follow-up questions, Rajiv, if you have time.
Make it quick because I have a lot of questions to cover still.
Sure. Sorry. First option I did talk about here is to switch to CPT and then file my extension H1 next year. In that case, what happens to my GC processing? I have my I-140 approved more than 6 months. So if I'm going on CPT, would I be carrying that to my new employer?
You have to start the green card all over again. That is going to be always true unless you are in 485 process. Before 485, you would always have to start your green card again, but you will carry your priority date with you.
And the right to extension as well, if it's pending more than 6 months, right?
More than 180 days, right to extension despite revocation by the old employer, yes. Okay?
Okay.
Good luck to you, sir.
And one more thing, so...
Dude, you're going to have to hurry up. I really
my
have
H1
a lot of ground to cover. So make it really quick. Please don't
Right.
just put...
If,
Go ahead.
yeah, so if my H1 got picked up in the lottery, can I go join the company as soon as I receive the receipt, or should I have to wait until it gets approved?
To the best of my knowledge, you cannot join. Okay? You have to
I
wait
have
for
to
the approval.
wait and...
Mm-hmm.
Okay.
Good luck.
Thank you.
All right, bye. Okay, guys, I do have a lot of ground to cover, like I said. So let's keep going. Okay, so this was one was from Kevin. So if somebody files an affidavit of support and they have filed their taxes jointly with their husband, does the husband also have to file an affidavit of support along with her? And the answer is, I checked. We've never had this situation before, but I'm pretty sure they don't have to. Okay? They don't have to. But what the rules for joint tax filings and how the taxes, etc., are apportioned, I do not know. I would have to look at it. But as far as you can review the instructions on the I-864, I do not know the answer off the top of my head, but I suspect strongly that there is no need for them to both sign. Okay. Star 5 if you have a follow-up question on this. Star 5. Next question, ST29, question number 9. They've got my wife and I have my immediate relative petition approved, but it's only good till July. Can we get an extension? And I have posted in the forums, if you look at forums under my name, Rajiv's Corner, I've posted a link to the consular rules for extension of an immigrant visa. I believe that they might charge you some extra fees, but they can renew the visa. Double check that link. I haven't looked at it for a while after I posted. So I think it should be okay. Star 5 if you have a follow-up question. Star 5. Yeah, so if you apply before your current visa expires, they should be able to extend it with some extra fees. That's what I remember. But double check. The link is on the COVID forums under my corner. Okay. Next question is number 10. So we have not received a biometric letter for H4. I heard that. Sorry, guys, a lot of texts. We haven't received an appointment letter for H4. Yeah, they have it on hold, the biometrics. So as far as I just checked before the call, I was talking with one of my colleagues in our firm whose team does all the H4 EADs. She said they're just holding on to the cases. But if they have your previous biometrics, they're reusing them. But for the first ones, the first timers, they are just holding on to the cases. They're processing the rest of the case, but they are not issuing EADs until biometrics. And this should have no impact on your wife's green card. I don't see any reason it should be impacted. Star 5 if you have a follow-up question. press star 5. Can USCIS completely stop the process was another one of your questions. And the answer is, well, if they can't do biometrics, they can certainly make that excuse and they can pause it for a very long time. Can they stop it completely? No. There's a follow-up question from New Jersey. New Jersey, go ahead, please.
Yeah, thanks, Rajiv ji. So the question is, biometric was done in India, so will that be considered here?
I don't think they are going to reuse those. I doubt very much. I think what they mentioned was biometrics done for another H4. So if they had an earlier biometrics in the context of your H4, this was a renewal, they will reuse the old one. This is what I remember. They're not going to get them from the consulate. Okay?
Okay. So Rajiv, one more question. Actually, I just received my H1B approval, and I noticed that the validity on I-94 is 10 days more than H1B approval date basically. So will that be any issue?
Is it just 10 days more?
Yes.
Yeah, that's normal because there is a 10-day grace period, and sometimes they just add it, so it's not a big deal. You're not allowed to work during those 10 days, but you can apply for a change of status.
Okay. Sounds good. Thank you.
Good luck. Okay, now the next question, number 11, is filed my 485 in 2012 and it has been in queue for approval. Application has been pre-adjudicated, which is good. Priority date is 2009. Any impact of the executive order? There is no impact and nothing you can do. It has no impact on you right now unless he comes up with something new. He's idiotic enough to do that, although I don't know how much he can make it last because his authority is temporary. And it is only while there is an emergency. So as soon as the emergency is over, or if he way oversteps his bounds, I think he's gonna have a problem. Okay. So far there is no impact. Star 5 if you have a follow-up question on this. Okay. So there is no follow-up question. This is number 12, Chinna codes. I've been with the company for 12 years on H1B, green card in 2010. I've got an EAD. Can I use the EAD to accept part-time positions, simultaneously start my own practice? I've already answered that question. And the answer is yes, yes, and yes. Only question is, for a green card, if you have a 485 pending for 180 days, I-140 is approved, you would ultimately need a same or similar job, full-time permanent, to qualify for a green card. In the meantime, or simultaneously, so if you have a job with IBM and you're working with them, at the same time you're doing some projects, your own contracts on the side, and that's not, let's say that's something you worked out with IBM, there's absolutely no problem. On EAD, you can pretty much do anything you want, as long as in the end, you've got that one job to fall back upon. Okay. Star 5, if you have a follow-up question. Star 5. All right. So let's see, where is this from? Area code 312, I believe that's Chicago. Hi, where are you calling from?
I'm calling from Chicago.
Yes, sir.
So I had a question. The explanation which you have given me, right? So there will be a need to transfer I-140 or new employer need to file a new I-140?
No.
That was the question.
No. Your 485 is pending 180 days, correct?
Correct.
You are one of those people who will use AC-21 portability of your job, of your green card. The entire green card is transferred based upon a supplement J offer of employment, which is same or similar. They don't have to touch the I-140. They don't have to touch the I-485.
Oh, so it's just supplement J, which is basically a job offer.
That's correct.
And for 140, there is another form. Okay.
There is no other
Got it.
form. So even the I-140, 45, everything. So it's a transfer of the whole package. Okay.
Correct.
Anything else?
Okay. And that is AC 140?
No, it's
What
called
is the transfer of the whole package?
No, it's called AC-21. AC-21 is a abbreviation for American Competitiveness in the 21st Century Act. That's the law that gave you that option. It's called AC-21 in short. Okay?
Okay. Thank you very much.
You're welcome. Good luck. I have another question from area code 805. I don't know what that is. Where are you calling from? 805?
Hi, Rajiv. This is Shekhar here. Back on number 12, I had a follow-up question.
Okay. Where are you calling from?
I'm calling from LA, Los Angeles.
LA. Okay. Now you've been with the company for 12 years. You want to do a part-time position, etc. Start my own practice. Yes. Go ahead with your question, please.
That's right. So the crux of the question, so the reason I was asking was that I had heard two different versions on that, which is one is that the H1, the moment I use EAD for the part-time or for my own practice, I go on to the EAD status. I have to relinquish my H1 status, versus the other version being that I can, that doesn't happen, and my H1 status as well as EAD both will remain valid. So I was not sure as to which is the right version, and I think that was the question that was bothering me.
It's a pretty long discussion, and we have a set of frequently asked questions on it. What happens to the H1 when the 485 is EAD is used? So please listen to the frequently asked questions. I don't want to go over the whole thing all over again. I won't explain it to you. The frequently asked questions would be under probably the title, should I renew my H1 while my EAD, while my 485 is pending? So the bottom line is it's all reversible, not the end of the world either way, but do listen to that frequently asked question. Come back with any spillover questions, okay?
All right, thank you.
Good luck. Okay, so we did the 13 number already. Question number 14. My L1A is expiring. I think you already spoke with me. I'm pretty sure I've spoken with you. I think you were either you can set up a consultation or you did talk with me through another community. I don't remember exactly. If you are on the phone, press *5, because I'm pretty sure we've talked about this. *5 if you're on the phone. Okay, so I'm not going to answer this question. I've already discussed it. I'll do it very briefly. So if you came in on a blanket and you want to do an individual L1, no problem. Or if you don't want to do an L1 extension through individual, you want to go through blanket, no problem. If the blanket gets denied, can you do an individual L1? Yes, you can. Okay. Next question, number 15. I'm on H1B with approved I-140. Existing petition expired in December. Timely extension was filed. I'm closing in on my 240 days. Can I apply for B2 in case I get a denial? Not if you get a denial, because you may not have any grace period left. But discuss your case. If you get a denial with a lawyer, maybe there is an option to file a B2. Normally filing a B2 if you're out of status is not much use, except where you are desperate. If H1 extension is denied, usually candidate needs to be outside USA. Can they reapply using out of cap H1B approved I-140? Look, just because an H1B has been denied doesn't stop you from applying for another H1 with the same employer or another employer, as long as your first denial is not a quota denial. So let's say you got selected for the quota and then got denied, then of course you're back in quota. But let's say you did an extension, you're already out of the quota, and the extension got denied. You could file, if you have time remaining or time to claim, you can file an extension again. You may be outside USA, or you can even file for a transfer with another employer while you're outside USA. Third question, COVID situation, if I have to stay put in USA after denial, can I reapply H-1B? Well, you can, but you won't get it within USA. And we have talked about the COVID situation. There are two things. One thing I've suggested is file B1, B2, even though you are out of status and unlawfully present. At least if we ever end up before a court, you have something to tell the judge, please put me back in B2 status. I have an application pending. So that's an important thing. The second thing I said was that our association, American Immigration Lawyers Association, has already filed a lawsuit against the government asking them to freeze all immigration deadlines for 90 days after the emergency is lifted. So we don't know where that is going to go, but that's also pending. *5 if you have a follow-up question. *5. Okay, this is from area code 224. Don't know where that is. 224, where are you calling from?
Hello, Mr. Rajiv.
Yes, sir. How are you?
I'm from Illinois.
Yes, sir. Go ahead. What's up?
So just to follow up on, right, so you're saying since I'm in the RSC and I'm still waiting on 240 days, I can at this point do another H1 with another employer, file for it while it's pending because the existing one has expired.
You can apply, but you won't get an H1 within USA. There's no harm in applying, but you'll have to go outside for a visa stamp.
So I'll have to go out once it's approved. I have to go outside and get a new H1B stamped and come back in.
The way they look at it, and I think it's illegal, I think they need to be sued on this. The way they look at it is this. If your past status has expired and the current extension, transfer, amendment, whatever is still pending, we won't give you another approval until that case is decided. Okay. So if we approve it, we'll approve it with visa stamping. You have to go outside, get a visa stamping done. Okay.
Okay. Just curious, if let's say if I file with another employer for a transfer at this point, and let's say my current one also gets approved, and the transfer also gets approved, then I can choose.
Oh yes, absolutely, absolutely. One does not trump another. So you can have both of them live together and decide which one you want to do.
Okay.
All right.
And just one last follow-up on the 240 days since I have already expired. So there is no option of B2. I mean, based on what you said earlier, if the case is pending for more than 240 days, I can stay here. We just can't work for the current employer.
Unless they file an amendment.
I don't need to go.
They should look at, I don't know if the amendment option works for you because the 240 days it might work. So you can have your lawyers check into it to file another amendment while this one is pending. I don't know what the implications are. You might be able to start working on that. All right.
Okay.
Good luck.
Thank you.
You're welcome. Okay, so now we are at question number 19. And this is from Imi Kumar. I have below follow-up. There's another follow-up question. Guys, don't take this much time. I can't keep going back. Area code 505. Where are you calling from?
Hey Rajiv, this is Mahesh calling from Michigan. Thank you for your continued service to our immigration community, and
yes,
I appreciate your team's effort for organizing questions so well. Just wondering, did you happen to cover question number 15? I just heard you are going to number 19.
15. I might have skipped it. Never know. Oh yeah, we covered that. We covered that.
So my wife's situation is also pretty much same, Rajiv. So knowingly or unknowingly, they are thinking it's okay to furlough, and they're saying they didn't terminate or they didn't send any notice to USCIS to revoke the H1.
Let me tell you something. That's the dumbest thing an employer can do. If they furlough you,
because some employers are like that, Raju, where they have like a handful of employees, like 5 or 10
It
employees,
doesn't
and they
matter.
have
It
thousands
doesn't
of
matter.
American employees.
It doesn't matter.
Okay.
Because you can always file,
Okay.
if they furlough you, let's say, heaven forbid, they furlough you for 6 months. You can, 6 months later, you can file a complaint with the wage and hour division. You'll get 6 months salary.
Yeah, that is good, Raju. So on the employee side, are we okay or are we at fault
No,
in some
you are,
perspective?
look, you are out of status, but you should be forgiven because it's not your fault. Okay. So,
but technically, since we are out of status.
Right, but this is a classic case where the government should excuse your being out of status.
Okay. So is there anything that employee could do in this situation where employer says you are okay with your status even being on unpaid leave?
Try to have something in writing. Try to have some record of them saying no, you can't.
Yeah, I sent email and they did respond back saying they checked with the attorney and the attorney said it's okay. So we have that proof.
The word dumbass comes to mind, but that's okay. So the bottom.
No, that is true. That is true. But based on all the education that you are providing us, we know it's not okay. But employer thinks it's okay. So
yeah, there's nothing else you can do. I mean, as an individual, what else can you do? Okay, so don't worry. Have some record, and I believe that I'm available. You don't bring me in. You don't give me salary, you don't offer me a one-way ticket back to my home country, you haven't fired me, so you're responsible for the salary. And the moment you file that complaint, I would argue that you are in status, you were always in status, you were just not paid.
Yes.
Okay. So I'm not that worried about it. I'm not that worried about it.
Okay. Yeah, but some places or some attorneys, they say like the moment you stop receiving the paycheck, you are out of status.
Why?
So I just wanted.
Why I'm available for work? I would like to test this out in court.
Because they think like even though employer didn't fire you or send you the termination notice, even though they said temporary layoff, still you are out of status is what I'm hearing from
I disagree. I would like to test that out in court. My theory is very simple. What is the difference between a guy who's getting full payment now and guy who's entitled to payment but not getting paid? No difference, just a matter of not having a check. So I am entitled to be paid, and the Department of Labor will step in for me. Let me ask you this question. So let's say I don't get paid for 6 months. Then after 6 months I file a wage and hour division complaint and they get me my money back. Does that not put me back in status?
Agree.
Okay.
Yeah.
So it's just simple logic and it's not that complicated. This area or this particular preposition is not that complicated. I would be surprised if any court can find for the government in this case. I think you have done everything you could to maintain status, and if you are not able to, the employer is required to pay you. Okay.
Yep. On the similar lines, Raju, another quick question is like, one of my friend is into like same situation. He learned that they are gonna furlough tomorrow, so he submitted a letter for leave of absence voluntarily on his end for about 2 months.
I've heard other lawyers advising.
For about 2 months, is that fine?
Look, I might as well make this clear for everyone. Please make sure you tell everyone, as many people as you can. The way this works is, and I'm running out of time, but let me just finish this up because this is important for people to understand. The way this works is, the law allows employees to voluntarily take leave of absence. If the employer wants to accommodate them, it's okay. You are still maintaining status. Department of Labor has given examples of where this kind of leave of absence is allowed. For example, for tourism. Okay. So leave of absence is good if it is voluntarily submitted by the employee for their benefit. But if the employer says, I got no work, I'm going to lay you off, or I'm going to, you have to submit a leave of absence, that's illegal. You'll be allowed to, you are in the same situation as a furlough.
Yeah, it is illegal, Rajesh, but in my friend's case, he learned that they are going to furlough, so he wanted to be kind of in status because he was not aware that they are going to terminate.
I think that's a bad idea, but it is what it is. Some lawyers are saying, oh, when you have this situation, apply for a leave of absence. I say absolute BS. Don't do that. Sit tight and take it up with the wage and hour division. You'll get your money back. Okay.
Okay, Raju. Thank you so much, Raju.
You're
Thanks
welcome.
a lot.
Good luck, sir. Yeah, guys, I had to cover that issue. It's coming up too frequently. I have no way to. Okay, let's see. All of this is done. Number 19. Oh, yeah, that's the one we were doing. B1, B2 change of status due to job loss. I understood from your last week conference, in case filing B1, B2 and the case is still pending, you found a new job, you have to go outside for visa stamping. That is correct. So the questions are, if I travel outside and and the USA embassy rejects our visa for some reason, can I return? You can try getting a B1, B2 visa stamping from them to wind up. You can't come back just to have your kids study, but you can try to come back for winding up your affairs. Okay. So yeah, there is, or you can even refile the H1B. I don't know why the visa would be denied. So it also depends upon the grounds of denial, but reapplying the H1B and B1, B2 are the two options that I can think of. Can I use my B2 pending application to come back to the USA? No, you cannot. If you leave USA when a change of status application is pending, H1 to B2 change of status, that change of status is abandoned. It's gone. COVID-19 situation, once my H1B is approved, can I start to work? Not unless you get an I-94. Not unless you get an I-94, no. Star 5 if you have a follow-up question on this, Mr. Kumar. Okay. Area code 570, go ahead. Where are you calling from?
Hi Rajiv, good afternoon. I'm calling from Pennsylvania.
Yes, sir.
How are you?
How are you?
I'm doing good, thank you. So this is the question I posted. So if any of such situation happens, and if I need to go for a stamping, so in the situation, is it a good idea just I go alone and try for a stamping, and in case anything happened, I cannot come back, so I just stay in India, and then only my family can continue here because my daughter is going for high school.
Yeah, they would be.
Then can we apply for any other?
They would be illegal, sir. They would be illegal, but can you do it? Yes. Should you do it? I don't know about that. You may have to have your daughter finish high school in India. I know of some people who were able to get a tourist visa when their kids were in school, and they stayed here for years. But it all depends upon the consulate. So they can give you a B1, B2 visa to come back and finish her high school while she goes to school on an F1 visa.
Okay, so in that situation, your suggestion is when I get a H1, just go as a family and then try to get a visa,
Right.
like a H1 or B1.
Right.
Go to consulate.
Right. And
then
just
try that
the only
option.
thing is, if you have gone to school in USA, you would know that in order to convert to F1 status, she will need an I-20 issued by the high school. Make sure that the high school she goes to can issue an I-20. Not all schools are authorized to issue I-20s. Okay.
So I need to get that before I travel to
Either before
USA,
or they can send it to you if you need it.
Okay. All right, Rajiv.
All right.
Okay. And then I need to wait till to get my H1. Then only I can come back.
That is correct. Yes, sir. Okay.
Okay. Great.
Good.
Thank you.
Good
Thank
luck.
you. Bye
All right,
now.
bye-bye. Raghav Reddy wants to know how soon will I get my green card. I could not even begin to guess. I'm so sorry. I can't tell you that. Oh, somebody else has a hand up. Area code 814. Yeah, 814. Go ahead, please. Where are you calling from?
Hey, Rajiv. This is Sean calling from Milwaukee.
Yes, sir.
How are you doing, sir?
Good. How are you?
Dad? Doing good. I'm a new member to your forum and just posted a question. So I've been on a green card for 5 years, and I was getting ready to start the naturalization process. But I had a question because, when I got my green card, I left my company in 1 month because lots of things were changing.
Okay.
They were a big
Let me put you on.
Fortune
Let me put you on hold.
500.
Hang on. I'm not taking new questions right now.
Yeah.
I actually was not going to take new questions.
Okay.
But since you have asked me, sit tight. Let's just finish up the other 2 questions that are left. I'll come back to you. I'll take another.
Sure. Thank
So
you.
I can't predict, Mr. Reddy, how long it will take to get your green card. Then the last question we have today is, if you are a U.S. healthcare worker, or if you're a healthcare worker, do you get any special consideration for green card? The answer is no, not so far. So there's no way to expedite your family-based visa application, given your skill set. But what you can do is, doesn't hurt to check with your congressman's office. There's no non-political way to do this, but maybe there's a political option. So contact your congressman's office and explain to them that you can be contributing to the fight against coronavirus. Never know. They might be able to work something out. Okay. So going back to, I'll just answer one additional question. You said you just worked for 1 month with the green card employer, and that's okay. I don't see any problem with that. You see, what is important is that on the date your green card was approved, you had no intention to leave them right away. Okay. But even if one day after the green card was approved, you got a great offer and you changed your mind, I don't see any problem. You stayed a full 1 month. And I personally think that the idea of working with the same employer for a long time has become defunct, especially because of AC-21 green card portability. Remember, now you can just take your green card and go anywhere after 180 days anyway, right? So I think that 1 month is not going to be an issue. Okay.
But are there potential questions of
absolutely.
Prove that you had no intent?
They will question you about the color of your pajamas. They are so stupid these days. This Trump effect. When you have a dumb guy at the top, everybody gets dumb. Okay. So basically what's happening is that you have a proliferation of extremely stupid questions and stupid situations, but not everybody. I mean, there are plenty of people in USCIS who are disgusted with silly procedures, and you may not have to be subjected to any kind of nonsense. But yes, the naturalization interviews tend to be very, very thorough these days. Okay.
If I may, one last follow-up question. So does it help to wait beyond the 5 years so that company's name doesn't come up in my 5-year history?
You can do that. I don't see any reason why not. But I think it's not hard for them to figure it out. But yeah, I don't think that's a bad idea. Just a couple of months more, right? So no big deal.
Yep. Okay. Thank you, sir.
You're welcome. Good luck. Okay, guys. I do want to answer any other questions. I'm going to do my best. Oh, there is another one from California. Okay. Area code 925. This is California, right? Go ahead.
Yeah, Rajiv. This is Raghav Reddy. So the question was not specific to when I will get my green card, but more of the priority date got moved this month. So are there anything else pending? I got my 485J in November 2018, and biometrics is done also in November 2018.
I saw that, yes. I saw that. And the answer is still, have you been interviewed by the government yet?
No,
Okay.
that's the only thing.
Yeah, so they will interview you, and who knows? I mean, not necessarily, but they usually do. Because your case was filed so long ago, they may not interview you. See, after a certain, I think it was it May 2017 or 2018, that they are interviewing everyone. Before that, it was only sporadic. They would just pick and choose. So you may not be interviewed.
Yeah, 2017.
Yeah. So they may not even interview you. You might just get your green card in the mail. Okay.
Okay. Yeah.
Good luck.
Thank you.
Good luck.
Thank you, sir.
So guys, I see that you have four people have their hands up already. Well, 3 now. Oh, 5 now. Okay. Let's see. Put your hands up. I'm going to try to answer as many questions as I can. Okay. Try to keep it short, please. Let's. Okay, this one I'm done. Give me a second. I'm trying to move my controls around. So this is done. Next one in the line is area code 570. 570, Pennsylvania. I think that's done already, actually.
Hi, Rajiv.
No, wait. You are 908, right? Or are you 570?
I'm 570.
Okay. Go ahead, Pennsylvania. How can I help you?
Yeah, just in case of COVID-19, if I lose a job, then I will be getting a 60-day grace period because I have 140 approved. So in the situation, say I found a new job, and then I do a H1 transfer. So in that situation, in case if I'm not filing B2, then can I just start to work for the new H1 employer?
The answer is yes. If your H1B transfer is received by the USCIS within the 60-day grace period, you are allowed to start working as soon as the application is filed. Okay?
Okay, and then once it's get approved, after some time, still I need to go outside USA to get it stamped, or just I can continue to work?
You should be able to continue to work because you have been maintaining status. Okay.
Okay, Rajiv. All right. Thank you very much.
Good luck, sir. Okay, let's take the next one. This one is 908, so that's New Jersey. New Jersey, go ahead, please.
Rajiv, this is a follow-up question again about the CAP exam to CAP subjective. Can I ask this question or should I wait?
Go ahead. No, I don't want to leave anything pending for you guys. They were poking their head in asking me other questions. I'm just going to ignore all that. So I want to finish your questions. Go ahead. What is your question?
Thank you. I'm waiting for the solution since last 4 years. So I want to make sure I got everything correct. Let's say I've completed my 6 years of CAP exam period, and now if I want to transfer to CAP subjective, is that possible after 6 years on H1?
If your I-140 is approved or PERM has been pending 1 year, definitely, why not?
Okay.
So in other words, let me phrase it differently. If you are in a legal position where you can get extension beyond 6 years for your CAP exempt H1, you can also get it for CAP H1.
Okay. And other comment that you just made for another colleague or another person is that once you receive a notice that your H1 is picked up, or once the transfer is, when you apply for a transfer, and if you have received a notice that it was received by USCIS,
no,
you can start working for them.
Let me correct that. The law, the way I read it is, the day they receive the paperwork, you can start working. You really don't have to wait for a receipt. That's a smart thing to do. But if you are desperate, you can start working as soon as they receive the paperwork.
Okay, it's not just picking up in the lottery. You have to file for it, and then once your packet has received and you receive that acknowledgement, then you can start.
Okay, no, wait. Your case is different. You are going from.
Mine is
yours
different.
is different. This is for that guy. For you, it is different. You have to wait for the approval. See.
Okay.
See.
That's better.
Right.
Okay.
Your case is different. So if you were letting go of your non-quota job and you wanted to go completely to the quota job and you applied for the transfer you applied for the lottery, you got the lottery, you applied for your H1 for the quota job, you cannot start working until October 1st or when the H1B is approved, whichever is later. So if H1B is approved on August 1st, you can't start work till October 1st. If H1 is approved on November 1st, you can't start work till November 1st. So you can only start work when the H1B is approved or October 1st, whichever is later. Okay. So yeah, but concurrent H1 is different. You may have to check on the law on that. I don't remember off the top of my head. I think concurrent H1 you can start working as soon as you file.
Okay. Sounds good. And one more question. So because of this COVID, I was reduced to 0.5 FTE, and I'm asked if I can work on another activity that's related to COVID, which is not of my job role, but my job title or the pay rate wouldn't change. Can I accept that, or should I not?
Well, if it's a volunteer activity which is not paid, there's no problem.
They pay me as the current pay rate, and they'll keep my title as intact, but that's just the
that's
that
not
they
it.
need.
I have to look at the two job descriptions to compare them, to make sure they are not sufficient, they are not too different. If the old job and the new job is about the same, no problem. If there is too much difference, H1B amendment would be needed. Okay?
Okay. I think that's a different job altogether.
Yeah, no, you can't. You have to do an amendment then. Okay?
Okay. Yeah, sure. Thank you.
You're welcome. Okay. Let's go on to the next one. We still have two more questions left. This one is from area code 919. 919, are you North Carolina?
Hey Rajiv, yeah, I'm North Carolina.
Okay.
So I asked this question to like the call previous to the last call, and I had a follow-up question that I'm on my STEM OPT and my H1 got picked and approved.
Good.
And then I filed my case as consular processing, but I got laid off before I could stamp it.
Okay.
So now that I'm applying for new jobs, so people ask me, what's your visa status? So either I can, that's where I need your advice. Like, should I tell them that I'm on my student visa?
So has your OPT expired or are you still on OPT?
I'm still on OPT till next year.
So what your current status is F1. Okay.
STEM OPT, yes, F1.
Right. So your current status is F1. No. What do if your employer asks you what is your current status, the answer is F1. STEM OPT is an extension of the F1, right? Student status. Okay.
Yes.
So then
they ask me like the future.
And you can.
What would you like to do?
And you can also tell them that to the best of your knowledge, you are not subject to the quota because you have an H1B approval. USCIS has created a lot of confusion. They have said we don't consider you to be exempt from the quota just because we approved your case. Until we approve your change of status to H1 or you go get visa stamping done, we don't consider you to be out of the quota yet. As a practical matter, we have done many cases in your type of situation. We've always been able to avoid the quota.
Okay. Yeah, I guess that was my question.
Good luck to you, sir.
Thanks a lot.
You're welcome. Bye-bye. Okay. Now the last question is from my neighborhood, Washington, D.C. Go ahead, Washington, D.C. Hello. Go ahead, area code 202. Oh, let me try again. Area code 202, can you hear me?
Yeah, I can hear you. Can you hear me?
Yes, ma'am, I can. Go ahead. What is your question?
Okay, thank you so much for this call. I'm on a TN visa. I've been on a TN for 5 years from Canada, and I just got laid off 2 days ago. And so I just wanted to confirm that I have a 60-day grace period in the U.S. Is that correct?
I believe so. I am. When does your status expire, ma'am? Current status?
You mean like when did my TN
yes. What was the
originally go until?
Right.
Yeah, March 2021.
Okay. So the answer is I'm 99.9% sure. But if you send me an email to help@immigration.com, I'll confirm it for you. I have it in my notes. What they did was they put 60-day grace period in almost all working visas. H-1B, L-1, TN, all of them. But I'll double check and let you know.
Okay, thank you. My next question is around unemployment insurance. It seems to be confusing about whether people on a TN can apply for unemployment insurance during their 60 days.
There are 2 or 3 different factors that you have to look at. First of all, the unemployment, well, actually, there's really 2 factors. The third one is kind of irrelevant. The 2 factors that are important, first is the state law. Bottom line is, you are a US worker or you are a worker in USA, you're allowed to take unemployment compensation. But the state law may not allow you. Why? Because the state laws say in order for somebody to receive compensation, they must be available for work. TN, L1, H1, all these visas are not really available for work because they're only allowed to work for a particular employer. Okay? So the state law might be a problem. Federal law would not create any issue for you. What should you do? You should check. You should check with the authorities in the state you're in and see if a non-immigrant visa holder can apply for and receive unemployment compensation. Okay.
So I live in D.C., but my company is housed in Colorado. So do I contact the Colorado?
Now you are putting me in waters where I am completely out of my element. So the reason is, I don't know anything about compensation laws. I can tell you this, my angle, immigration law will create no problem for you. Where should you apply, Colorado or DC? I do not know. Check with your benefits people or just call the local, they used to call it, was it Department of Economic Development or whatever the local job office is where the compensation is applied for. Contact them. They should be able to guide you. I do not know the answer to that.
Okay, got it. And so my last question is that during my grace period time, whether that's 30 or 60 days, am I allowed to continue to volunteer?
It will be 60 days. See, that word volunteer has so many connotations. So if you're not getting paid for it directly or indirectly, you can do whatever you want. Can somebody, for example, stop you from going and volunteering in a temple or a church? Of course not. You can do whatever you want. Take it a step further. What if you want to go for a political rally or volunteer for a local political candidate? Why not? As long as you don't get paid for it, you can do what you want.
Got it. So after my 60-day grace period and I go back to Canada, can I come back to the United States to take care of my house and things like that on a visitor visa?
Not based upon those 60 days, but based upon being a favorite daughter of the United States because you are a Canadian citizen, you could always come as a visitor.
Okay.
Okay.
Thank you.
And then I guess what about stimulus money? Do how do I find out if I'm eligible for that?
Do I call the IRS?
If you go to LinkedIn, I have a LinkedIn. I created a chart. I posted it on my Twitter account. I posted it in LinkedIn, on my Facebook. If you go to immigration.com, in fact, you know what? Just When you email me, I'll just send you a link to that page. I created a graph that tells you how to determine whether you are going to get paid and how much you're going to get paid.
Okay. Thank you so much for this.
You're welcome. Good luck.
Thank you.
Bye-bye. Guys, thank you so much for being here. I always enjoy talking with you. I'll see you again in 2 weeks. Stay safe, everyone. Be well. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.